So let's start looking at GDPR. There's a few eye rolls already. Hopefully, this is just a refresher and you're all familiar with this material. But just in case, it's the General Data Protection Regulation. Anyone know when it came into law? May 23rd-ish? Okay, close enough. 25th of May last year it came into law. Okay, so this is not something that's upcoming. This is something that's already on the statute book. And in the UK, the relevant piece of legislation is the Data Protection Act of 2018. You may not have heard much about that. You may mostly have heard about GDPR, but the Data Protection Act is just as important, and I'll show you why as we go along. It doesn't matter where your business is based anywhere in the world. If you're handling personal data of people from the EU, this law applies to you, especially the people who are watching this on YouTube later on. Now, some of you have worked in a regulated industry, but many of you haven't. And when I was researching this talk, I was trying to think. I couldn't think of any other regulation that applies to everyone in the room like GDPR will. Couldn't think of anything. And my advice to you is get used to it. We've enjoyed 30, 40, best part of 50 years of practically unregulated software development. Those days are coming to an end, and GDPR is only going to be the start of it. There is already more legislation coming down the pipeline, and that will affect us regardless of what happens down in the House of Commons later this month, as the UK is committed to maintaining alignment on these standards. So be aware of that. And of course, many of us, our software will be being used by people from outside the UK. So you can't get away from this stuff. You can't get away from it if you're doing free and open source software either. There is no clause you can put in your license file to say GDPR does not apply. If you're handling personal data, it applies. You need to be aware of that. We have a concept in European law and in British law. You cannot sign away your rights. In America, you can. Over here, you can't. Your rights trump any contract you can convince anyone to sign. So be aware of that. You cannot water down GDPR. If you are involved in open source, anyone heard of web dev law? So maybe saw Heather's talk at Scotland PHP back in October. Well, she's put together some guidance for how open source projects can deal with GDPR and comply with it. And that QR code will take you to her current guidance. Please do go have a read of it. Even if you're not involved in open source, her guidance is very easy to follow and very helpful for all organizations. So what I'm going to do now is I'm going to, as a refresher, take you through some of the requirements from GDPR and also that are in the Data Protection Act. Usual caveats apply. I am not a lawyer. I'm not stood up here pretending to offer you legal advice whatsoever. I want to make that absolutely clear. What I've done is I've lifted this section from the advice that's already online from the ICO website. And hopefully, especially those of you in leadership roles in your organizations, you've got this website already bookmarked. If you haven't, you should be. Now, this website discusses GDPR in two terms. Don't worry about snagging the link now. The slides will be online after the talk, so don't worry. It provides 2 points of view for getting your head around GDPR. It talks about the obligations on organizations, which as developers impacts us. And it talks about the rights that GDPR and the Data Protection Act gives us as individuals. Obviously, these two come together to form an intersection. So let's go through the obligations first. This is the headline. And you may not have seen this actually stated in such black and white terms before. If you are holding something that is classified as personal data, and we're going to look at what that is in a moment, you need a lawful basis to hold that data. No ifs, no buts. You require a lawful basis. Without a lawful basis, you cannot hold the data. According to the ICO, that means you need to be able to identify the lawful basis for every single piece of personal data you've got in your systems. You've actually got to be able to point at your data sets as a whole and say, this is personal data, this isn't. You've got to be able to say what is and isn't personal data. You've got to keep track of what you've done with it, what you've used it for. Data processing. The ICO talks about data can only be used in ways that are fair. That's an interesting term, shall we say, especially in these historic times. The explanation talks about making sure data is used in non-discriminatory ways. But go read the advice for a whole section on that. Now, one of the ways you can legally hold data is by asking for someone's consent. That's one way you can do that. It's like the opt-in box, okay, that we're all used to when we sign up for things. It should be opt-in, not opt-out. You have to get explicit consent for what you're going to do with that data. If you haven't got explicit consent because you've come up with something new you want to use existing data for, you've got to go back and ask for more consent. You can't just reuse the data because you've already got it. The guidance is very clear on that. There's a concept, a principle of minimal data. You can only ask for data that you actually need for the processing you're going to do. You can't just ask someone for consent for storing data that you don't need. Again, you've got this principle that you can't sign away your rights as an individual. Okay? So you've got to store the minimum amount of data possible. Which means, of course, if your processing changes and you don't need as much data anymore, you may need to scrub the data you've already got consent to hold, which is something you don't see people talk a lot about. There's a concept here that you're not allowed to hold data that's factually inaccurate. Not all personal data is facts. Some of it is opinion, some of it is the result of processing, which we'll look at in a moment. If you hold personal data, but it's inaccurate, you are required to correct it or remove it is another exceptional alternative. You're not allowed to hang on to incorrect data. You can't keep data for any longer than needed. Once your lawful basis has lapsed, you're supposed to get rid of it. And you're supposed to delete it proactively. That's a theme that's going to come back up later on in the talk. Now, they don't just mean a soft delete here. You've got to scrub this stuff from everywhere. The ICO website explicitly mentions backups and archives. Okay, you can't hang on to it on a backup tape somewhere. If you've been told to delete it, you've got to get rid of it from everywhere. That also, although the ICO website doesn't talk about it, means you've got to get rid of it from your staging environments and from your dev environments as well. Be aware of that. You can't keep a copy of it anywhere if you've been told to get rid of it. Now, you may be passing this data on to third parties. That's lawful under certain circumstances. Any data you delete, you've got to tell those third parties that you've deleted it, because that may mean their lawful basis for holding that data may now have lapsed, which means they may need to delete it. And you're also required to tell individuals that those third parties still have that data. Okay? This one should go without saying, but as we've all seen from the regular data breaches, it's not the case. But they're talking about all personal data. They're not just talking about secure passwords here. They don't make a distinction in the guidance. It just says personal data. So technically that means names, addresses, and things like that as well. And it's not enough to just jump through all those hoops to comply. You also actually have to keep evidence that you've been complying over time as part of your compliance. So those are the obligations on organisations. Hopefully it's just a refresher for you all. But we'll see. Now, individuals. We all have rights now, which we didn't have before. And they're typically broken down into 8 areas. I'm going to, again, run you through all of these. When someone wants to collect your personal data, they're supposed to provide you with something that is known as privacy information. That is a defined term in the guidance. It's more than just a privacy policy. So you'll want to go, if you're not familiar with that, you want to go to look at the ICO's website to see everything that's involved with that. If you get someone's personal data from a third party, Maybe you're processing it on their behalf, or maybe you've bought a data set, for example, for direct marketing, which is a thing. Okay? You're supposed to contact everybody whose data you now have and provide them with your privacy information, because your privacy information may be different to whoever they originally gave the data to. But there is an asterisk there. One thing about GDPR is all these strong black and white statements often have caveats to them and only apply under certain circumstances. And this one in particular is so watered down. I'm personally curious to see whether this is ever enforceable in practice. We may find it's not. There's a thing now that's known as a subject access request. You can ask an organisation to tell you what personal data they have on you, and they've got a month to comply. They've got a month to provide that. How many of you are confident that right now, if you hold personal data, that you could give them all that data within a month? Yeah, it's challenging if you haven't built for it. And when you're actually fulfilling a subject access request, you've got to make sure you don't leak anyone else's personal information into the bargain. You're not allowed to do that. And as we've seen with recent CPU bugs, like Spectre and things like that, the interaction of data can be mind-blowingly complex, and you can end up leaking things that you never intended to. So this one could be quite challenging in the long term. Someone can ask you, you can issue what's called a rectification request and say, you've got factually incorrect data on me, you need to repair it. And you've got a month to put that right. Okay? So this is the flip side of some of the obligations we've seen earlier on. You can issue an erasure request and say, I no longer want you to hold that data. And if, for example, the only reason you've got that data is consent, that means your lawful basis may have lapsed, and therefore you've got to delete it. And again, you've got a month to do that. Now, you may have heard that described as the right to be forgotten. There's a bit more to it than that. If the personal data is about a child or someone's childhood, someone who's now an adult, the right to be forgotten has extra obligations that you'll need to go to the ICO website to learn more about. You can't treat everyone the same. This is something that I only came across when doing the research for this talk. This was something I wasn't aware of. If someone's disputing the factual accuracy of data, they have the right to issue what's called a processing restriction request. So you don't have to delete it, but you're not allowed to use it whilst you've got it. And the ICO website's got some suggestions about how you might go around implementing that. But I'd never heard of that one before, doing the research for this talk. Has anyone else come across that? No. That one's certainly got implications for event sourcing. There's a concept of data portability. You're supposed to be able to take your data and take it somewhere else. But again, one of those pesky asterisks. This one only applies under very specific circumstances, and only if the data is already held in a computer system. So if the data is on paperwork, for example, you don't have the right to data portability because the data is not already in a computer. The right to object has been the headline that people have talked about since GDPR came along. But we're going to put that in a separate section because it throws up something that you may need to know about. This is one of my favourite rights. Anyone phoned up an insurance company who drives a car and you've been given a quote, and when you challenge the value of that quote, the cost of it, they say, well, that's what the computer says. Yeah? Anyone had that? I am hoping that GDPR says that's no longer an acceptable answer. Because insurance affects your legal ability to drive a car. Okay? You're not allowed to drive a car without that. And solely automated decision making, you can no longer just say that's the output, the algorithm. You've got to be able to explain how you got that result now under GDPR. We have the right to challenge that. We've also got the right to ask a human to double check that. To replace the computer's working out with someone else's working out. And to challenge those results. So this is about correcting data again of a form, but not personal data. It's about correcting the results of an automation that may already be stored in a database. And this is another one of my favorites. If the work you do falls under what's called solely automated decisions, and that's a defined term which has a lot of defined scope around it, doesn't apply to all computer operations. But if your work falls under that, you've actually got to be testing it on a regular basis. So GDPR may have actually made testing mandatory for some of us, legally required for the very first time. I don't know if you were aware of that. Nope. Now, I said about the right to object, and I wanted to break that out separately. The thing is with GDPR is a lot of these black and white statements, when you go and look at the detail of the advice, there's a lot more to it that you need to know and understand. And they're commonly called exemptions. And I came across them while researching the right to object, because it's probably one of the biggest areas of the ICO guide. And there's the link to it, if you want to go away and read this for yourself. See, the thing is, this statement I made earlier about personal data, covering the personal data, not all of it. Not all personal data is personal data according to GDPR. There's what's known as our exemptions. And these exemptions aren't defined in GDPR. They're actually defined in the Data Protection Act, which I haven't seen people talk about. But the ICO website says it in black and white. That's where you go and find them. Unfortunately, you don't have to go into the legislation. They've got a section all on exemptions for you, which you'll want to go and read. There's far too much there to keep in your head. Now, here's the rub of it. That exemption list is only the UK's. There's 27 other members of the EU. They've got their own list under their own national legislation. So if you're handling personal data of people from any other EU country, you may need to go and find the list for their country and make sure you're complying with that as well. I don't know if many of you are aware of that. I certainly wasn't until I was researching this talk. It's not something I've seen people really talk about. Now, one of the reasons I've given you a general overview of GDPR rather than just pick stuff out that applies to event sourcing is I'm trying to show you what it's like to work in a regulatory environment. Regulations are complex. I've worked in telecoms. My wife's worked in finance. Everything we had to do had to go through a compliance team who were trained, and many of them often had legal qualifications, to sit down and interpret this stuff for us and tell us whether what we wanted to do was legal or not, whether it met the regulatory framework. You need to get that sort of advice.